Hi, I'm Kevin Jensen with the law offices of Kevin Jensen. The Arizona Supreme Court just came down with a decision in a case that can have a dramatic impact on the property rights of couples who have purchased a home during a marriage and are going through a divorce. For decades, it's been the American dream for hardworking couples to save their money and to buy a house where they can raise their family and spend the rest of their lives together. Usually this means going to the bank and getting a loan to buy the house because most of us don't have enough money to buy the house for cash. In the early 2000s, after the real estate recession, banks became much more stringent on lending money. One of the things that they started doing more frequently is looking at the credit of both parties who were seeking to buy the house. If one of the spouses had bad credit, they started requiring that spouse to sign a document called a disclaimer deed. The disclaimer deed transferred ownership of the house from both parties to only the spouse with the good credit, and that's who the bank would lend the money to. Now, in most cases, you're probably thinking, what's the big deal? We're going to live happily ever after in this house, and nobody's ever going to look at the deed and care what it says on the ownership documents, unless you get divorced. And this is where the new case issued by the Arizona Supreme Court comes into play. In a case called Saba versus Khoury, the Arizona Supreme Court found that if a spouse signs a disclaimer deed, even if the house was purchased during the marriage with community funds, the spouse who signed the disclaimer deed may lose out on a significant amount of their share of the equity of the home. This can obviously be very devastating. In order to determine what spouse gets what percentage of the equity in a home in this circumstance, the Supreme Court devised a very complicated formula that determines each spouse's share of the equity. This complicated formula depends on many factors, including where the down payment of the house came from, how the mortgage payments were paid during the marriage, whether the couple made improvements to the house, such as a remodel, and where the money for that remodel or the improvements came from. This formula is very hard for a lot of inexperienced attorneys to understand. Here at the law offices of Kevin Jensen, we have a fantastic team of highly experienced attorneys who understand these complicated real estate issues in divorce cases. These complicated cases often require us to go to trial to fight for our clients' rights when it comes to these property rights. Now, I have two pieces of important advice as it relates to this particular issue. First of all, if you're a married couple contemplating buying a house and the bank asks one of you to sign a disclaimer deed, before you sign that disclaimer deed, I would advise you to talk to a highly experienced family law attorney who could advise you as to the legal consequences of signing that disclaimer deed. There are options to avoid the problems that I've been talking about in this video. Second of all, if you've already signed a disclaimer deed and you're going through a divorce, you need to have an attorney who really understands these issues and can fight for you to make sure that you get as much money as possible from this important asset. For most people going through a divorce, the house is the biggest asset they have. The money that comes from each spouse's share of the equity often becomes the lifeline for restarting their life after the divorce. It's very important that you have an attorney who understands these issues and can fight for your property rights. If you or your spouse signed a disclaimer deed on a home that you purchased during the marriage, or if you've been living in a home and paying the mortgage on a home one of you owned prior to the marriage, you need a real expert to handle your divorce. Here at the law offices of Kevin Jensen, we're here to help you.